Welcome to Ask a Lawyer with the attorneys at Karen and Ulmer PC. Today, it's Michael Raisman. He focuses on family law, estate administration, and real estate law. Join us as Attorney Raisman answers your questions about the law and how it affects you.
Michael, what are the steps needed to be named an executor of a will?
Sure. So the executor is when there's a will. When there is no will, then you can be appointed as the administrator. If named under the will, then the first thing you should do is go to the Register of Wills in the county where the decedent lived, and you'll need to bring with you the original will, photo ID of the executor, a death certificate, and a checkbook. At that time, you'll be granted letters testamentary and issued short certificates. If there is no will, then you'll need the next of kin, the spouse or your siblings, children, to sign renunciations. If the next of kin won't sign renunciations, then you'll need to file a petition with the court to have an administrator appointed, and then the court will make that determination as to who should be appointed as the administrator.
Who is normally named as an executor or administrator?
Typically, it's a spouse, a child, parent, some close family member or friend. You're going to want to name someone who's trustworthy and responsible. When you are named the executor, there's a lot of work that needs to be done, including advertising the estate, filing and paying inheritance taxes, cleaning up and selling real estate, working with attorneys, paying the bills of the decedent. So you do need someone who is someone who's up for the challenge, someone who's responsible and will get things done at a reasonable speed. Whoever you're going to be naming as the executor, you should discuss prior to creating the will.
Yeah, good point. So you name some of the things that an executor does. Is there anything else, and how can a person learn what they need to do?
So there's a lot of information online as to what an executor does. Probably the best resource is to speak with a knowledgeable attorney who can answer questions for you, such as myself. When you're preparing a will, talk to an attorney. Find out who would be best to be the executor. If you are appointed as the executor, talk to an attorney. Find out what your responsibilities are. You want to make sure before you sign on to becoming the executor or the administrator, you want to make sure that you're able to handle these tasks.
Now, here's a term I keep hearing, power of attorney. What is that, and is that needed in these kinds of situations?
So a power of attorney is a document that's created prior to your passing. Once you pass, the power of attorney is null and void. So this is a document that's important to have during your lifetime. What it is it's a document that gives someone authority to act on your behalf, to talk to doctors, to talk to banks, to talk to credit card companies, to act as you. Again, the person you're going to pick as an agent, you do want that person to be responsible and trustworthy. The reason that it's important is in the event that you become incapacitated, you want to make sure that you have someone appointed ahead of time. So this way, it's easy for the person to take over immediately, someone who the doctors can rely on, someone that they can talk to. If you don't have a power of attorney, then you'll need to a family member is going to need to file for guardianship in the event that you become incapacitated. Power of attorney, it's a fast process. You get a document done usually in a day or two. It's relatively cheap. Whereas to file for guardianship is expensive, it's stressful, and it takes several months to get to court, going through the court process. Power of attorney is definitely the way to go, and you want to do that as part of any estate planning preparation.
Okay, let's circle back around to executor of a will. Are there? I've been named an executor of a will. Let's say, are there any potential liabilities I should be aware of?
Sure. So an executor is responsible for maintaining accurate records, paying creditors, and eventually distributing funds to the beneficiaries. If an executor distributes funds to heirs and a creditor files a legitimate and a timely claim and the estate no longer has enough funds to pay the creditor, then the executor will be liable for getting the funds from the beneficiaries. If the executor cannot get the funds from the beneficiary, then he or she is personally liable to pay the creditor. no matter what, the executor does need to maintain full records and accounting, because if a beneficiary comes back and says, wait, I didn't get what I need, they file with the court. It's your burden to show that that the funds were paid appropriately, that you need to show exactly what happened to every penny that that the estate had, so that you can show that to the court.
Should I be compensated as an executor of a will?
So executors and administrators are permitted to be compensated as acting as personal representative. There's a schedule based on the size of the estate that's been determined through prior case law. Compensation to the personal representative is tax deductible for the estate. However, it's taxable to as income to the personal representative. So there may be times when it's not worth collecting. For example, if you're the sole beneficiary and there's only a few debts, then the inheritance tax rate may be less than what your personal tax rate is, in which case it's better to collect as under the estate than it is to collect as compensation. However, it could be worth it in some cases. It's best to speak with an attorney or an accountant prior to making the decision as to whether or not to claim any kind of compensation.
Yeah, good advice. Michael, is there anything else we should know?
Sure. So as far as estates go, once you open up the estate, you should move quickly. It does take about a little over a year to resolve everything, as you have to advertise the estate once it's opened, giving creditors 1 year to make a claim. So usually you want to wait the 1 year before you make any substantial distributions to any beneficiaries or heirs. The only other substantial deadline would be the inheritance tax. The tax rate's based on who's inheriting. If it's a spouse or a charity, there's no taxes. However, if a child or a parent is the beneficiary, there's a 4.5% tax rate, 12% to siblings, and 15% to anyone else. The deadline is 9 months from the date of passing. However, you get a 5% discount in the event that you pay it within 3 months. If you don't have the inheritance tax filing within 3 months, you can make an estimated payment, and you'll get the 5% discount based on the estimated amount. So if you whatever you pay, you'll get 5% off of that.
Thanks for listening to Ask a Lawyer with the attorneys at Karen and Ulmer PC.